It is a socialist movement to transfer immense amounts of wealth from the people who have worked their rear ends off to establish this or to create this wealth to the people who are living in the apartment buildings. I'm not going to say they're not responsible, and I'm not going to say they haven't worked hard, but they have not done the steps necessary to amass this wealth. So the state of California is transferring it to them for free. And then the reasonable accommodation requests, this one, it's kind of a neutral law, but basically what it says is any reasonable accommodation request submitted by either an applicant or an existing tenant has to be kept confidential. And the way this comes up a lot is you have an on-site manager and the tenant walks over and submits their reasonable accommodation request. And maybe the tenant is open about it and tells another tenant on the property, yeah, I'm going to get a dog. You just watch. I'm going to get a comfort pet. I just submitted my application. Then the other tenant that has not yet requested the animal comes over and talks to the on-site manager and says, well, hey, I know Kris just turned in their application. And the on-site manager starts talking about the application, maybe mentions what Kris's disability is. It's that kind of stuff that is completely confidential now. The only exception to that confidentiality is you can release the information to somebody who is part of the interactive process or the interactive decision-making process. So for example, Kris, if somebody turned in a reasonable accommodation request to you and you weren't sure how to navigate it, you could pick up the phone and call me, and I'm part of your team that helps you navigate that decision-making process. So you'd be okay disclosing the information to me.
Got it.
But otherwise the information stays confidential. All of it does. All right. So now we're moving on to the recently introduced legislation. And again, this is just 2022, what's come up. In fact, a couple of these have died already, and I'll talk about that. AB 936, that streamlines the ADU additions and increased height limits process. So what was going on is currently we have a lot of landlords who already have an ADU or something like an ADU on their property, but they couldn't get it permitted because it's higher than the current height restrictions. This is streamlining that process to get that approved. Okay. They just want to get as much housing as they can online. AB 854, prohibitions on the Ellis Act removal, that just died yesterday. So that's gone for the year. AB 1241, Jones-Sawyer, this was the ban the box. This bill is in effect, this law is in effect in San Francisco. In fact, this is the law that says a landlord is not permitted to ask about any sort of conviction during the initial part of the screening process. So in other words, you weren't even allowed to have it on your application. Have you ever been convicted of a crime? But that died. The owner actually, the sponsor, Jones-Sawyer, actually pulled that bill off. It's dead. That bill's been around now for probably 5 years. Like I said, it's already in effect up in San Francisco. They will keep bringing it back. You will, even if it had passed, you will eventually be able to have some parameters and criteria. It simply says you can't ask about convictions in the initial phases of screening.
So for right now, my LA County, San Bernardino County, again, those areas you service that my clients own in, if an applicant has a prior criminal conviction, you can deny them simply based on that.
You can, but there are some caveats to it. So for example, you have to ask yourself several questions. How long ago was the conviction? What was the conviction for? So those are the two main questions. So if it was 20 years ago and it was conviction for drunk driving, if I were a landlord, I would not use that to disapprove of him or her.
But if it's theft, physical body harm to somebody else.
Yeah, absolutely.
Okay.
Yeah, so you can deny, but you want to be judicious in how you're approaching it. AB 889 is Gibson bringing back that corporate disclosure requirement. SB 140 is the framework. Now, this one's really interesting, the framework for the California Dream for All. So you remember we talked about that new law that passed that puts California into the traditional banking role, right?
Mhm.
This Dream for All Act is, right now they're developing the framework so that the state of California will be providing the down payment for tenants to purchase properties, to be homeowners. It's not in place yet. They have to come back with a report. I think it's by July of 2020. Don't quote me on the year. I think it's July 2024. They come back with the framework for that. And if it's feasible, like I said, the state of California will be providing the down payment for the tenants to become homeowners. Now, that's really interesting. I'm going to circle back to that in a little bit when we get towards the evolving trends. We've got SB 649, which is the local low income tenant preferences. This is a really interesting law because this is an attempt to prevent, it's an attempt to handcuff landlords when it comes to who they choose to be their tenants. So what this bill says is that if you have two equally qualified candidates, they don't even have to be equally qualified. If you have two applicants, one is very qualified, but they're not local. But another one is local, but they're really not qualified. They're low income tenant, and they're not meeting your criteria. As a landlord, you would have to take the local tenant over the non-local qualified tenant if this bill passes. So again, it's really hamstringing the landlords in their abilities to pick the most qualified applicant. And it's forcing them, if it passes, it will force them to take a low income tenant who's local over a high income tenant who maybe is moving in from out of state or something.
So we should tell the banks, you got to base your application approvals on who lives closest to the branch as opposed to who could pay back the loan. Is that the
essentially? Yeah.
These people, the line of reasoning, it's a bleeding heart over rationale. Anyways, sorry.
Right. No, it's all right. Well, it's pandering, really, is what it is. California is a state of renters, and certainly, of course, LA is a city of renters, but California is a state of renters. It's kind of a vicious circle. Every single law they pass has a negative impact on housing, but that gives them the battle cry that, hey, housing is very difficult here and unaffordable, so we need more laws. But every law they pass makes housing worse. So they don't seem to understand that, or they do understand it and they don't care.
Well, and people need to understand you can't just live everywhere. I want to own a home in Beverly Hills, but you know what? I can't afford it. So you buy what you can afford, right? But it's this mentality of, well, I want it now. Somebody owes it to me. There's people out there who have money, so they should pay for what I don't have. It's just,
you just nailed it, Kris. It's transfer of wealth. We're going to talk about that in the evolving trends, but essentially it is a socialist movement to transfer immense amounts of wealth from the people who have worked their rear ends off to establish this or to create this wealth to the people who are living in the apartment buildings. I'm not going to say they're not responsible, and I'm not going to say they haven't worked hard, but they have not done the steps necessary to amass this wealth. So the state of California is transferring it to them for free. All right, so SB 747, moving on, we've got grants to landlords denied rental assistance. This is a proposed law that any landlord that's been denied the rental assistance under Housing is Key or any of the local ones for COVID rental assistance funds, they will be able to apply for a $5,000 grant. Right now, I haven't seen all of the language of that bill, so I can't really talk about it in great detail. What I can say is I have some concerns, obviously. What if you're in the middle of an eviction and you fill out this grant and you accept that money? Does that kill your eviction? I don't know yet. So before anybody, if this passes, before anybody goes and runs out and starts filling out the paperwork, look into it, and they can call my office. By then I'll know more about it and figure it out. And then SB 848 is an increase in the renter tax credit. It's my understanding the tax credit hasn't been increased for renters since 1979, I believe it is. And I read somewhere that the increase is going up to, I think it was some enormously low rate, like $750 a year for a single person. That's being bumped up to $200,000 a year for a single person and $400,000 a year for a couple. So it's a huge increase in the renter tax credit. My concern with that obviously is California is now essentially giving renters a tax credit of up to $200,000. So the state of California doesn't walk away from money at any time. So if they're going to give the renters that tax credit, where are they going to pick up the taxes that they're losing? From the owners. And we've seen it many, many times. They're attempting the split roll tax. They're attempting to, get rid of Prop 13. They're attempting to reassess properties after Prop 19 passed, which we'll talk about in a second. So they're not just walking away from that money. Again, transfer of wealth to the tenants. Here, we're going to give you this huge tax credit. It'll lower your taxes, but don't worry about it. We're going to pick that up on the increased taxes on these owners over here. All right, moving on. Those are the bills that have been introduced in 2022 that we've just talked about. Now we're going to talk about the ballot initiatives. As we talked about in the beginning, 2022 is a primary election year for California, actually for the whole country. And here are some ballot initiatives. I don't have the time to go into them. Look it up and start understanding what is going to be on this ballot. And kind of as a joke, I'll just say, what difference does it make? Because everybody will remember that statewide rent control was on the ballot and the voters soundly defeated it. And then the state of California went and enacted it anyway. They just basically thumbed their nose at the voters. So I'm not sure the importance of these ballot initiatives, but they're here anyway. So the first one is local control over land use and zoning laws initiatives. That is giving the locals control over their zoning laws, which is, I know there's arguments for both sides, but essentially what we're going to see if that happens is a patchwork of zoning take place all over the state.
Right. There's no doubt we need housing, but do I want a 6-unit apartment building showing up in my neighborhood when I bought into a specific neighborhood? Because,
that's right.
Right.
Exactly right. We have the Tax Cut and Housing Affordability Act of 2022. I highly encourage people to look that up and understand the details, start educating themselves about these things. The Affordable Housing and Financial Accountability Act of 2022, same thing, please look it up. The Taxpayer Protection and Government Accountability Act, look it up. And my favorite, this is the one I will talk about, the Repeal the Death Tax Act. So Prop 19 passed last year, as everybody knows. And essentially what it said was, hey, when you die, your single family property is going to be reassessed and you won't be able to pass it on to your kids with that step up in basis the way you used to do. So the concern right now is that many of the kids who would have inherited those properties, they may not have the economic wherewithal to even pay for a stepped up tax, yearly tax obligation. So this one is going to be on the ballot to pull 19 off, to get rid of Proposition 19 that passed and to do away with that. That one is sponsored by the Howard Jarvis Tax Association. All right, let's talk about, I'm not going to go into details in this, just to touch on them. The city of Alhambra is looking into its own just cause and rent stabilization ordinance. Beverly Hills is considering doing away with their moratorium, their eviction moratorium, but it won't matter because LA County's is kicking in and it's going to control the whole county. Right. Culver City had a seismic retrofit that went into effect. Glendale, they toyed with a tenants committee, but it actually failed. Los Angeles City and Los Angeles County, their moratoriums have been extended. Long Beach has a temporary restriction on substantial remodels. So you can't even do those right now in Long Beach. Manhattan Beach said as of March 1st, their eviction moratorium is rescinded. Again, it doesn't matter because they're part of LA County who's extending theirs. Oxnard and Ventura are toying with rent control and tenant protection acts. Pasadena, this is interesting. They had, I don't know if it passed, but they had on their city council agenda a bill to permanently ban all gas appliances in new construction and commercial. And it is not a secret that they are moving toward banning gas appliances even in existing stock down the line. Mm-hmm. The problem, as everybody knows, is we don't have the grid, we don't have the infrastructure to start converting everything over to electric. So it'll be interesting to see how that plays out. Redondo Beach also considering, Redondo Beach is a really interesting one. I believe it passed, but now in order to remove a tree off your own private property, I'm not talking about an oak tree, I'm talking about any tree, you have to go to the city's planning and development department and ask them if you can get permission to remove the tree. And then West Hollywood, again, they're toying with the idea of revamping their tenant protections and moratoriums. So a lot going on all over the place in LA County.
Let me ask you, Mike, because as I hear this, and obviously things are always changing and developing. If a landlord is, say, using an older style rental agreement, or even let's say they're using the AOA rental agreement, given all the new regulations and the moratoriums and the different, now there's different notices for this and that, is it worthy of them too? And is it even something you do if they come in and say, Mike, we need to meet, I own 2 10-unit buildings, I'd like to show you my rental agreement, help me update this thing, is there anything that I need to include, or are there any additional notices? In other words, do you kind of do an overview consultation with them to help them clean up maybe what they haven't done in terms of documentation the last few years, to ensure, given all the new regulations in place, that they're within where they need to be? Is that something that you do? Is that
Yes.
advisable?
So let me paraphrase what you're asking. Will I meet with clients, review their leases, and give them an overview of what they need to do to be in a protected position, right?
Yeah, and even just if they say, hey, here's when I have a vacant unit, this is typically how I go about it. Here's a sample of my advertising.
Yeah.
Basically, you do an overview of their rental business, the legal aspect of it. Because as much as I know, I feel like I'm stepping in hot water, at least in 4 places,
Yeah. So the leases we certainly will look at, and I do it all the time. I do it multiple times per week. I have consultations with people. They send me their documents. I review them before the meeting, and then we have an hour consultation on what needs to be done. And I'll tell you, Kris, it's surprising to me that these are still out there, but the one theme that I see virtually every time I look at leases is the attorney's fees provision in the lease is inadequate. So I'm going to take this opportunity to tell all of your listeners, review your attorney's fees provision in your leases. And if you have an uncapped attorney's fee provision, it'll say something like, the prevailing parties entitled to reasonable costs and fees. That's an uncapped provision. If you have an uncapped provision, reach out to me immediately and I will draft you an addendum. It's $150. It's very cheap. We'll draft it and we'll serve an addendum changing that to protect you from evictions, from lawsuits, stuff like that. There's more to it than that. I've just summarized it. But that's the thing I would tell every landlord out there right now. At least twice a week, I run into this situation where I'm telling them, okay, the first thing you got to do, because oftentimes I run into situations where the landlord they should be doing an eviction right now. The laws are on their side to do this eviction, even in the moratoriums, but they've got this open-ended attorney's fees provision. And if they lose the eviction for whatever, a hyper-technical reason, the opposing side is going to come back to them after them for $25,000 to $30,000 in attorney's fees. So before we file on the eviction, what we do is we send out the change in terms of tenancies and change that attorney's fees provision to cap it at $500. And then, believe it or not, when these tenants' rights firms pick up these cases, they will bluff you still. They'll still demand a jury trial. They'll still hit you with discovery. But when it comes down where the rubber meets the road and it's time to actually have a jury trial, one of two things typically happens. They either waive the jury trial and have a bench trial, or they sub out of the case entirely and the tenant's on their own now, and that allows you to move forward with a bench trial rather than a jury trial. Why do they do that? Because if they know their fees are going to be capped at $500, even if they win, it's not worth their time and money to move forward with a jury trial. So I see that all the time. So the shorter answer to your question is yes, I do review this stuff all the time. Your listeners should call my office, set up a consultation. I'll look at their documents. We draft leases. I'm going to tell you they're not cheap, but they're incredibly thorough. Your typical trade organization lease right now with all the addendums is going to be anywhere between 3 pages to maybe 8 or 9 pages. My lease is going to be, we're closing in on about 30 to 35 pages, depending on what jurisdiction you're in. So it's built for 10 years down the road, anticipating all the changes that based on trends that I see, anticipating the upcoming trends and protecting the landlord for a decade.
Yeah, well, and even I think I have a pretty good rental agreement. I have a really well-written addendum that was written by some attorneys some time ago. And I think the idea is you just want to have your tenant, so to speak, wrapped in a straitjacket so that it's real clear. If they step outside the boundaries, it's real clear that they did so. And when you go to court, there's just no mistaking that given a sane judge, it should be in your favor. So anyways, Mike, I know that we have went through a mouthful today. I want to thank you again for your time. I know soon enough, you, I, and the other speakers we have will be together at our in-person educational event for the local landlords, where you'll be able to do a deeper dive and expand, more so on your opinions on how things are shaping up here in California and the trends that we see. But this definitely serves as a good opener and intro to the year. Hopefully there won't be much more change beyond what we've already seen. But thank you for helping us, the landlords, and getting us prepared for the rest of the year.
You're very welcome.
Excellent. Well, I know our prior interviews have thousands and thousands of views, and the reason why is because we stand behind what you and your firm do, the quality of work, the attention to detail. So we highly recommend landlords seek your advice, and I hope they do so. And Mike, until we speak again, be well.
Looking forward to it, Kris. Thanks again.
All right, thank you. With that, I hope you found today's show informative. I hope that you'll review your leases, take a look at your documentation. Do you need a consultation with an eviction attorney to see that you're in line, keep yourself out of hot water, and that you're advertising your vacant units correctly? As we know, the laws and regulations have everything to do with how our financial legacy works out in multifamily investments. Be sure to subscribe to our channel and share a comment with us. Are you finding the content helpful? What additional content could we provide that would be meaningful to your ownership? We're here to serve you, the landlords. Kris German, the apartment dealer, and as always, wishing you positive cash flow, tenants who behave, and much protection from Uncle Sam. Till next time.